Donald Trump is seeking an appeal of the D.C. Circuit Court of Appeals ruling affirming the district court's gag order in the case involving Donald Trump's attempt to overthrow the results of the 2020 election. I'm Ben Meiselas from the MeidasTouch Network. So how is Donald Trump appealing an appeal before going to the United States Supreme Court? Well, it's called a petition for an en banc hearing, meaning a petition that the entire D.C. Circuit Court of Appeals, all of the members of the D.C. Circuit, review the decision by the three-judge panel from December 8th, where that three-judge D.C. Circuit Court of Appeals panel that oversees, that is the boss to the trial court judges, in this case, federal judge Tanya Chutkan, where that D.C. Circuit Court of Appeals affirmed the gag order. Here's what Donald Trump filed, and it is a bizarre document, to say the least, filled with gaslighting after gaslighting, page after page. Donald Trump's petition for panel rehearing and en banc consideration and request for administrative stay pending consideration of this petition. Though all of that is basically what I described at the outset of the video, except for the part where it says administrative stay. Donald Trump wants to request once again, while this petition is pending for an en banc panel for all of the judges to hear it, he wants to be able to go out and start attacking people again and threatening people again because the gag order is now imposed on him. So he wants that paused. Let's take a look at some of the arguments that Donald Trump makes here, because you'll see how outlandish, disingenuous, and gaslighting it is. For example, it says that a panel hearing before the full D.C. Circuit Court of Appeals, in other words, en banc, is warranted because the panel opinion overlooks or misapprehends material points of fact and law. So Donald Trump is going after the ruling by the D.C. Circuit Court of Appeals, and here's an example that that Donald Trump gives. He says, "When I stated, if you go after me, I'm coming after you," what Donald Trump really meant, this is what he argues, quote, "Trump's post did not refer to the case at all, even though it happened the day after the indictment." Donald Trump says it didn't refer to the case at all, but to contemporaneous reports that the Koch brothers were funding PACs against him, political action committees against him. So Trump says, I wasn't posting that the day after the indictment as a threat to witnesses or a threat to Jack Smith or a threat to the judiciary. I was threatening the Koch brothers right there. So you see, again, this kind of just loserish mentality that he has. He doesn't even own the fascism. He doesn't even own the authoritarianism. It's all gaslighting. Oh, I threatened the Koch brothers. That's what it was. And here's what he argues as it relates to former Vice President Pence as another example that he gave. He goes, the panel that affirmed the gag order stated that Trump's social media posts accusing Vice President Pence of going to the dark side and making up stories about the events of January 6, 2020. But the reality was, Donald Trump argues, is that Pence at the time was a rival candidate for the Republican nomination, and that Pence had just given a speech accusing Donald Trump of all of these lies. So Donald Trump said he had to respond in order to attack Pence for the political speech that Pence was giving. And that's why Donald Trump says that he was going after it. He says, for example, going after Pence. Donald Trump says, for example, Pence campaign updated its merchandise offerings to take advantage of the allegations that Pence made against Trump with a hat and a shirt, both bearing the two-word phrase, quote, "too honest." And so because Pence was selling merch that said "too honest," Donald Trump then had to attack him and say he was going to the dark side and making up stories about the events of January 6th, 2020, and therefore Donald Trump should not be blamed for doing that. And then Donald Trump says over here, these examples and many others demonstrate that the First Amendment injuries are not allayed by the panel's opinions attempt to narrow the scope of the district gag order. The order as modified by the D.C. Circuit Court of Appeal panel still suppresses a large amount of the speech that Donald Trump claims he needs to be able to engage in right now. So he wants the entire D.C. Circuit panel to hear this. Let's just take a look at what the group of three, the three-judge panel at the D.C. Circuit Court of Appeals actually ruled. They said the district court judge's gag order, the gag order by Judge Tanya Chutkan, this is the December 8th order by the D.C. Circuit Court of Appeals, that order is affirmed. The Judge Chutkan's order is affirmed to the extent it prohibits all parties and their counsel from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding. The order is also affirmed, the gag order is also affirmed, to the extent it prohibits all parties and their counsel from making or directing others to make public statements about counsel in this case other than the special counsel, members of the court staff and counsel staff, or 3, the family members of any counsel or staff member, if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel or staff's work in this criminal case, or with the knowledge that such interference is highly likely to result. We vacate the order to the extent it covers speech beyond those specified categories. So the D.C. Circuit Court of Appeals was allowing Donald Trump to still attack special counsel Jack Smith and actually allowing Donald Trump to attack Judge Tanya Chutkan, but not the court staff, not the other lawyers on the case that work for special counsel Jack Smith's team, and also not the family members of the judge, special counsel Jack Smith, special counsel Jack Smith's team, and of course prohibiting any of the parties from threatening witnesses or those who are reasonably foreseeable to be witnesses. That's what Donald Trump is saying. The D.C. Circuit Court of Appeals, you got it wrong, so I now want an en banc hearing before the full panel, before all of the judges that comprise the D.C. Circuit Court of Appeals to review the three-judge panel. And ultimately, I have no doubt that Donald Trump's going to try to go to the Supreme Court. And Donald Trump, I predict, will try to use the Supreme Court appeal as a way to try to stay all of the proceedings going on in Washington, D.C. after, I believe, the D.C. Circuit Court of Appeals will, on an expedited basis, affirm Judge Tanya Chutkan's other order denying Donald Trump's motion to dismiss the indictment on absolute presidential immunity grounds. And by the way, when you look at the D.C. Circuit Court of Appeals order, they say, look, we do not allow such a gag order lightly. Trump is a former president and current candidate for the presidency, and there is a strong public interest in what he has to say. But Trump is also an indicted criminal defendant, and he must stand trial in a courtroom under the same procedures that govern all other criminal defendants. That is what the rule of law means. And the D.C. Circuit Court of Appeals adopted Judge Tanya Chutkan's factual findings that Trump's documented pattern of speech and its demonstrated real-time, real-world consequences pose a significant and imminent threat to the functioning of the criminal trial process in this case. And the D.C. Circuit Court of Appeals looked to Supreme Court precedent in the Gentile versus State Bar Association of Nevada case, where the Supreme Court held that the First Amendment allows a court to prohibit the speech of a trial participant when the speech poses a, quote, substantial likelihood of material prejudice to an adjudicative proceeding. So substantial likelihood of prejudice to an adjudicative proceeding, that's the standard that the Supreme Court previously announced. Here, the D.C. Circuit Court of Appeals found that Trump's documented pattern of speech and its demonstrated real-time, real-world consequences pose a significant and imminent threat to the functioning of the criminal trial process. In many ways, the DC Circuit Court of Appeals went even beyond what the Supreme Court was saying. The Supreme Court, I think, would allow even more restrictions. But here, the DC Circuit Court of Appeals is saying, look, there is real-time, real-world consequences that pose significant and imminent threats caused by Donald Trump's conduct. And then so in Donald Trump's petition for an en banc hearing, what Trump is saying is that the DC Circuit Court of Appeals applied an incorrect standard. The correct standard should be a clear and present danger, and clear and present danger test. In essence, someone has to be like about to be killed or actually injured before you can limit Donald Trump's speech. That's what Trump's arguing. And one of the things that the DC Circuit Court of Appeals said in oral argument and reemphasized in their opinion is there still has to be some sort of balancing of the behavior of a litigant, of a criminal defendant in a criminal case, or a litigant in a case before a judicial system. There has to be some balancing of interest here. And Trump's lawyers, and Trump has no balance. They just basically say he can say whatever he wants, and really only if he is about to harm somebody, like there's like actual, someone gets injured, only then can you step in. And the DC Circuit said that's just not the standard. But you just see all of the machinations here and all of the effort that Donald Trump goes through. In this case, in the New York case, to be able to threaten and attack people over and over again. Just think about the tens of millions of dollars every month that Donald Trump is spending of political action campaign money to file these types of documents. The relentless nature of it intended to just kind of overwhelm the adversary. And fortunately, here you've got Special Counsel Jack Smith in the DC case. And you've got great prosecutors, whether it's New York Attorney General Letitia James or Fulton County District Attorney Fani Willis or whoever, who are able to kind of keep up with it. But just think about it's relentless, it's nonstop. And you have those ridiculously kind of bad faith arguments that I said, well, I never said I was going to threaten them. I was talking about the Koch brothers. Ridiculous. We'll keep you posted as we learn more. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support, and have a good day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.